Hi everybody, welcome to this week's Facebook Live. This week I am interviewing Danielle Little of Estates Lawyers. Now bear with me because it is a few minutes to the hour and I am going to do the technology to get Danielle on. Hi Kelly, thank you for joining us. Now just bear with me while I grab Danielle. Hi Jacinta, thanks for coming on. So, for Kelly and Jacinta, we're just going to interview Danielle today to talk about notional estates. So I'm sure you guys are going to be really interested in that. Let me just bring Danielle on in a few minutes. Here we go. Hi Susan, thanks for joining us. Now the button looks like it's working for Danielle to jump on. While I'm just waiting for, I don't know what it's doing, processing or something. While we're waiting for that, we've got a really interesting sort of agenda to go through today. So we're going to drill down into some of the more tricky aspects of the notional estate. Now just guys, I'm so sorry, we're just going to bear with me while I get the tech working. And let's see how that goes.
Hi. Hi, everyone. Sorry, my dog's just going crazy in the background.
I'm doing nothing, and I thought, not again.
No. Hopefully everyone can hear me okay.
Well, I can hear you fine, and you're coming through nice and clear as well. So,
excellent.
Can you see the comments? Jacinta says, hi, Danielle.
I can actually see the comments. Hi, everyone. Hi, Jacinta.
Well, look, we've got a whole bunch of people trickling through, which is amazing. Everyone's adjusting to daylight savings, which I just had a last-minute panic about a minute before I thought, oh, what if I got one? So let's get started. Of New South Wales notional estate. Before we launch into that, Danielle, I was hoping you could just tell everyone a little bit about your experience and what you do.
Yeah, no worries. So I first started off my career in New South Wales doing estate litigation, and a couple of years ago I moved back to Queensland, where I've remained concentrating on wills and estates. So I started my own firm late last year, and the focus is basically wills and estates. So that's a bit of a brief history of what I'm up to.
Congrats on starting your own firm. That is gutsy.
Yeah, scary, but yeah, it's good.
No, good on you. So for everyone watching, Danielle and I had a bit of a chat yesterday, and she very politely reminded me, because I'm looking at notional estate through a planning lens, I've been looking at it in a pretty negative context. And if you're actually on the litigation side, it can be a really amazing tool. So Danielle, do you want to kind of talk two sides of the coin?
Yeah, no worries. So I love notional estate from a litigation perspective. I have a bit of a passion for acting for elderly people in elder financial abuse type matters. So for New South Wales clients, the notional estate provisions are really quite good, because what you do often see is an elderly person who, might be a widower, they have children, and one of those children or many of those children might be a power of attorney, and graciously convince their parent to transfer a property to them for the large price of $1. So for those types of matters, it's actually really handy to be able to claw back estate property or claw back property to come into the estate, because going down the path of an equitable remedy like undue influence, unconscionable conduct, capacity, those types of remedies can be extremely expensive. So be able to give someone the opportunity of a quick, easy resolution like a family provision claim where you can claw back property is really good for elderly people. So I love it for that. But from an estate planning point of view, it can be a nightmare.
Yes, and I have a question for you about that. That I won't raise that one yet though, because I guess could you summarise for everybody really quickly what they are, the New South Wales notional estates, if you've never heard about those provisions, if you don't practice in New South Wales?
Yeah, so essentially what they're designed to do is property transactions that occur, for instance, like someone transferring a property for $1 to a family member within a specific period of time, 3 years essentially. The provisions allow the court to make an order for various parts of property to come back into the estate. Now, the order can only cater for what is required to meet a family provision order if one is made. So the realm of what can be drawn back in is really just to cater if there's not enough in the actual estate to cater for the order, and potentially for costs as well. They're restricted to only the portion that makes up that part of the claim.
Okay, and so it's not automatically that all non-estate assets are available for a challenge. They have to have approval that particular assets are brought in. Is that right?
That's right. So the deceased actually, the law changed in New South Wales last year. Previously, a deceased person could be living either in New South Wales or outside of New South Wales. So jurisdiction shopping used to be a lot easier. It changed last year so that the deceased has to be domiciled in New South Wales, but the order can relate to property within or outside of New South Wales.
Oh, okay. Because I wasn't aware of that law change, because I have heard in the past that, yes, if you were in Queensland but you had assets in New South Wales, then that meant you could actually, the notional estate would apply. So is that not correct?
Yeah, so it changed, I think it was actually late last year. So it's only a fairly recent change.
Okay, well, that's really good news for practitioners who aren't in New South Wales, or where the clients aren't in New South Wales.
Yeah, but it's still open slather for the properties.
Yeah, okay. So Louise has just said there's no notional estate available in Western Australia, and so that's technically correct, but drilling down, the domicile has to be a state other than New South Wales, or if they were domiciled in New South Wales, then Western Australia property would be available.
Yeah, correct.
Cool, okay. And then you just mentioned that there was a 3-year clawback period.
Yeah.
Now, I actually printed out the legislation yesterday and was reading through it, and it says that if a person enters into a relevant property transaction, a person enters into a relevant property transaction if the person does directly or indirectly, or does not do an act that results in. So tell me about this does not do,
Yes, so omitting to do something with a property can also fall into the area. So there's a case which I can put the details in the comments section later on, which goes through it's called Hitchcock and Pratt, and it goes through the whole realm of company setup and transactions for Mr. Pratt. And essentially, if a deceased omits to do something, it's all about whether they actually had control to do that in the first place. So one of the things that you see as a common example for omitting to do something is severing a joint tenancy. So where someone has, say, a wealthy man, for instance, has a second wife, they remarry, and most of the estate property that they buy as joint tenants, if the deceased was really actually trying to cater for his children, for example, and in his will divides his property between his wife and 3 children, for example, and his intention was to actually sever that joint tenancy before passing away so that his estate could be divided in the way that he wanted to, and doesn't do that, then that is not doing something that would fall into that category, if that makes sense. I probably didn't explain that very well.
So, okay, well, here's another example. So in one of the recent Facebook Lives, I was talking about all the strategies in Queensland that I like to utilise to make sure assets are not part of the challengeable pool. So things like granting options over assets, that gift and loan back strategy, even choosing how to direct the binding nomination, so to directly to death benefit dependents instead of into the estate. So say it is like, okay, well, I guess what I'm trying to say is making a binding nomination outside of the estate to a dependent directly, is that a relevant property transaction?
That I'm not exactly sure of. I was reading a case actually just the other day that involved a binding death nomination. The deceased had actually made a binding death nomination, but failed to renew it. The 3 years expired and failed to renew it. Now, the court had decided that it wasn't him failing to actually renew that binding death benefit nomination wasn't necessarily an intentional thing to direct money away from his estate. It was just that he didn't realise and thought that it was still in place, and it didn't actually come in as part of notional estate into the estate. If he had have deliberately done otherwise, then it might have been a different story.
That's fascinating. Okay, and so I guess that leads us on to section 75 sub 3 of the Act, which is saying the purpose, or is it 75.3? Oh, sorry, I think it's a different section, but basically the purpose has to be to make sure the asset is not available in the estate.
Yeah.
How important is
I think from an estate planning point of view, the purpose being something other than taking assets out of an estate for the purpose of depleting an estate from family provision type matters. I think from a planning point of view, it's important to always have the dominant purpose something else. It needs to be, some other asset protection reason.
Yeah. Okay, and sorry, I've just checked. It's section 80, 2B and 2A.
Yeah.
So, so that is interesting if you can do it as part of a broader structure review. And I think some transactions will be more prone to being able to have other. So if we're doing things relating to family trust succession, gift and loan back, arguably you could say there are other commercial reasons for doing it as well to help sort of build an argument that what the dominant purpose was. But for instance, I think it hard with a binding death benefit nomination, perhaps.
Yeah. Yeah, true. The case of Hitchcock and Pratt that I mentioned before, it actually has a good outline of a pretty sound estate planning structure that was set up for Mr. Pratt. If you can get your head around the vast array of companies and structures that they go through in the case. I tried to do a diagram of it so that I could try and explain it a little bit easier in this session, but my diagram looks like a dog's breakfast. So, but essentially, what happened with the family trust in that case, the New South Wales property that was owned by a company, the court decided was not property for the purpose of a notional estate order, because it was owned by a company that was a long way down the line of subsidiary companies of the main company that was trustee for the family trust. So the deceased control couldn't go back so far to be at basically the bottom of the pyramid of structures to have control over selling those properties and benefiting the estate. He just didn't have the control. But even if he did have control over some of the other entities, he and his wife had a life interest set up in the trust, and they were actually excluded beneficiaries from the trust. So that was an extra layer of protection for him when it came to the New South Wales property.
Okay, so there are things that, well, I mean, there are recommendations that as advisors we can implement on the planning side.
Yeah.
It sounds like, firstly, we all need to read the case, and then secondly, it's going to be a balance of what's actually practical and commercial. Yeah. And I mean, so this is a significant estate, high-profile businessman, where there was a lot of who's already used to complex structures, and potentially it was justified, but arguably for sort of smaller mum and dad clients, some of these planning remedies are probably not going to be commercial.
Yeah.
What do you think?
Yeah, that's right. So I had a client, for example, in New South Wales who had a reasonable size estate. He had 3 children, 2 sons and a daughter. The daughter had basically disowned the family, wanted nothing to do with her father, and I was doing a will for him. It was pointless going down a set-up process being complicated. He just didn't have that amount of assets that were worthwhile. But she was an eligible person to obviously make a claim against his estate. So in those types of circumstances, I usually advise clients that they are an eligible person. If they do make a claim against the estate, it depletes the estate in terms of costs and then any provision that might be made for that particular daughter. And you never know what you're going to get with a judge. You know, you could get someone like Pembroke that just says, no, it's an estranged daughter and they're not getting anything, to other judges that will have a more sympathetic view and make provision. So I usually explain the process of a family provision application, what the cost can be in those circumstances, and advise them to actually provide for that particular person an amount that will hopefully, can't guarantee, but will hopefully deter them from actually making a claim. Because if you're providing provision for someone, say you've got a $300,000 estate, you want most of it to go to your other 2 children. If you give that particular daughter $30,000 or $40,000, for example, well, when they make a claim, not only do they have to get their 30 or 40 grand, plus they've got to get their costs, plus they've got to get something extra. So when they go and see, hopefully, a decent lawyer in relation to a family provision claim and go through the details of their relationship and the size of the estate, etc., a sensible lawyer would say, you're likely not going to get much more than that, and you could get less.
So I always wonder, is it worth looking at any of these types of strategies to minimise the estate where they're domiciled in New South Wales? And so I'm interested in your thoughts as a litigator when you are acting for someone who is eligible to bring a challenge and you see that they have done things that could be caught by notional estate. How much of a deterrent is that? Is it just, not really worth it, or does it sort of go, oh, it's a bit more complex?
Yeah, it really depends on the value of the assets. So you can, for example, they can change the ownership of their property, for example, how it's held, and if they do it a long time before they actually pass away, well, then it doesn't come into the time frame for a notional estate order. So similar to when I think it was last week's session with the 4.5 years that we were talking about, similar kind of thing. As long as you are not within that essentially 3-year period, if they have the right setup 10 years prior, well, that's a whole different story. But if they do it just before they die, then it's useless.
Yeah, actually, that's a really good point, because you're right. Once it's 3 years, it's done.
Yeah, so, that's right.
Yeah, I mean, it's so hard because you're sitting there, I guess, saying, well,
just don't die.
Please die within the next 3 years.
Yeah, exactly.
And yeah, I mean, I suppose with the bankruptcy clawback, the advice is always just do it early and get it done. So I suppose it's a cost-benefit analysis for the client and knowing that
that's right. The guarantee. Yeah, and at the end of the day, all you can do is give them the advice that is sensible within the realms of the value of their assets, and they choose what it is that they want to do. If they have the options and they're aware of the ins and outs of all of those options, then it's really a matter for them to decide what they want to do right now.
And Danielle, I think you have almost inadvertently answered Jacinta's question, so I'll just read that out for you. So Jacinta, if the simply refuses to provide a gift to the estranged child and they just want a simple will, you can to such an extent and hope the client will listen. So does it just ultimately become an estate issue?
Yeah, so I have had clients before with an estranged child who have just refused to provide anything for them in a will. And really it's a butt covering exercise for yourself to make sure that you, in writing, give them the relevant advice, what your recommendation is, and receive from them in writing confirmation of what their instructions are. You can't force them to do something. So it really becomes a point of just covering yourself.
Yeah, I always struggle with clients who are on notice that there could be a family provision risk and have the New South Wales notional estate, because it is such a hard discussion, and I always feel like it's hard for us to give them certainty as well about what are the chances of a claim, how much is enough, all that, and and at the same time we have to protect ourselves. And you can be very like doom and gloom trying to make sure that you've covered yourself. It's hard. It's a hard conversation.
It is hard. And you can do a will now. The law can change significantly between now and when that person passes away. So although you've put the right processes and the best formula together for them now, who knows what the legislation is going to do.
Yeah.
So it's really hard to kind of safeguard every scenario.
And I mean, I suppose that's a really good point in support of people should really be doing annual reviews.
Mm.
And as I think as estate planning lawyers who are sort of guns for hire and we come in and don't have ongoing engagement with the client, that can be hard for the
Yeah.
accountants and financial advisors on the live who have, you know, repeat ongoing contact with the clients. I think this is an area where you guys can add a lot of value to just make sure that it gets checked in annually. And look, you know, you're probably not going to know about the nuances of the changes, but you can at least initiate what's the estate, what's the estate pool done? Has it gone up or has it gone down? Maybe just a quick check in with the lawyer who prepared the will to say, hey, we just want to check that there's nothing that we need to tinker with around the edges of the estate plan. And I feel like that's a really big value add that you can to make sure that the strategy and the numbers remain current.
Yeah.
Oh, super.
Yeah.
Yeah, part of your job. Yes, I know you do that so well, Susan. Um, so we've only got 5 minutes left. That has flown by for me. Well, I'll just put a call out to people watching. If you've got any more questions, now's the time to send them through. And Danielle, was there anything else that you wanted to add that we haven't really covered off in our questions so far?
I think what would be handy if one of the financial advisors or accountants that listens to the session, if they had time to have a read of the structure that's in the Hitchcock and Pratt case, and maybe come up with a diagram of a slightly smaller structure that might provide protection for a New South Wales asset in a similar way to what it does in the case, but just not the long-winded pyramid that that's involved in that case. That would be really really handy from a financial advisor's perspective to just see that in a bit of a diagram if anyone has the opportunity or the time to do that.
Awesome. Yeah, well, we'll link that case and I'll have a read as well. And I'm very happy to keep the discussion going. So, for everyone who's watching, I don't know if this has popped up on your view in the group, but last week I created a few education units within the group so that we can collate the videos and the questions and the additional resources to different topics. So I'll add this to the notional estate family provision topic as well, and we can keep putting the comments in there, and that means everyone can keep coming back as an ongoing resource rather than it just sort of getting lost a couple of days in through the news feed.
Yeah.
Now, last call for questions, and Danielle, was that everything you wanted to say about notional estate?
Yeah, I think so. Yeah, I think that was pretty much it.
Well, I might summarize my lessons because I have to admit I know enough to be dangerous when it comes to notional estate. And I firstly want to say thank you so much, and I'll echo the comments that are coming through to say thank you for sharing your knowledge here, because that's digging down into the practical side that may not be at first obvious when reading the rules has been really valuable. I think the main lessons that I've learned out of it is firstly, understanding that it's just if you're domiciled in New South Wales, which is great that they've changed that because previously I have had concerns that, you know, everything could be in, say, Queensland, but if the registered office happens to be the accountant that's in Sydney, then the whole thing is open slather. So
Yeah, yeah.
feel really good hearing that it's just limited to the domicile of New South Wales. I think you've really emphasized to me the importance of the 3 years and having a chat to clients about the cost benefit analysis of taking steps now. So it's not going to give them a heap of peace of mind in the next 3 years, but once that's done, then
Yeah.
they can rest easy. And then lastly, I mean, I think all this has really shown is it's really important to get a specialist in the area where we're on notice that there is a challenge and
Yeah.
notional effect, because it is complex. There are strategies if you know what you're doing, and depending on the nature of assets that we can do to make the intentions of the test data more protected. But also it's a sensitive conversation as well. So having
Yeah.
someone who's familiar with the rules, who knows the strategies and can guide the clients through it can be really powerful. Now,
Yeah.
I'm just going to listen to comments while we've got you. Does the change read the domicile apply to wills made from a certain date, or is it to all wills made?
I would assume that it is essentially to all wills made.
I think so, because it would just be anyone who's died.
That's right. So they might have done a will 20 years ago, but they might die next week. So it depends on where they domicile next week when they pass away.
Yeah, correct. So
Yeah.
who's bringing a provision application, I think. I mean, I'm just guessing based on what I would assume they would do as common sense.
Yeah.
But good question. Yeah, really good question, Jacinta. Well, we're right on half an hour. Danielle, thank you so much for taking time out of your day to contribute to the group. I think everyone's found it so valuable.
Thanks for having me.
No, absolute pleasure. We'll put the case in the notes. Everyone has got your now. So you practice in Brisbane, in Queensland and New South Wales.
And New South Wales, yeah.
And it's estate planning and litigation.
Yes, estate planning and litigation, although I do try and avoid New South Wales estate planning where I can.
I can see why. Well,
obvious reasons.
Everyone has an awesome day. One plug for next week's Facebook Live. I am interviewing Tim Henry. So he is a Victorian financial advisor. Tim's been doing or project managing and facilitating estate planning for years now. And I just wanted to talk to him about the process from his side in terms of the value he finds he can add to his clients, the processes, the systems, how he works with lawyers, that kind of thing, for any of the advisors who are interested in taking more of a lead role in this for their clients. So, yeah, keep an eye on the newsfeed. I'll keep putting updates in, and I hope to see you all next